Almighty God, who in infinite wisdom and providential goodness has appointed the offices of leaders and parliaments for the welfare of society and just government of humanity, we beseech you to look upon with abundant favor these your servants who have been pleased to call to the performance of such important trusts in this land. Let your blessing descend upon them here assembled, and grant that they may, as in your presence, treat and consider all matters that shall come under their deliberation in so just and faithful a manner as promote your honor and glory, and to advance the good of those whose interests you've committed to their charge. Amen.
Item number 2, communication from the chair.
Honorable members, I welcome you to this sitting. And I received a letter from the Minister of Finance in relation to the National Environment Bill 2017. I don't know the chair of this committee, if that person, if the chair is here. This bill was brought to repeal the current law, which is in Cap 153, and it has some timelines in relation to issues of Bujagali and in relation to our partnership with the World Bank. And actually, it's required that this law should be in place by November 30th. I don't know where this bill is or who is still processing it. Is the chair responsible for this here, Natural Resources Committee? Because this bill should come out and we should finish with it to pave way for these other things to take place as they're required to. I've also received another letter from the Minister of Finance in relation to the Tax Procedures Code Amendment Bill 2018 for consideration. We need to cross-check whether the letter from the President has actually been read in Parliament. It was read. Has it been referred to the committee? Has the motion for reconsideration been sent?
Thank you, Right Honourable Speaker. Right Honourable Speaker, the letter returning the bill was read and referred to the committee, but there was no motion accompanying bill, yes. What we asked them to do was to send us the returned bill, which we expect them to do.
Okay. So, honourable members, we need to also finalize with this. Whoever is still holding the sent copy of the bill, which should have been brought with the letter from the President, should be brought so that we can finish with this thing. And that should also apply to the biotechnology law, which was returned by the President. That should have been completed a long time ago. I don't know what it's still doing there. It's way beyond the time provided in the rules. That should also be finished quickly. And then, honourable members, yesterday, when I was adjourning, there was a matter that was on the order paper that is in relation to the loan for Nakapiripirit. Yes, there was supposed to be some alteration, some adjustment in the figures, so that it reflects the true spirit of that loan, and somehow it did not get on the order paper, so I'm accordingly amending the order paper to accommodate this particular motion for review of this particular matter that had been passed by Parliament, so that we can adjust the figures and let the processes continue. So the order paper is accordingly amended to accommodate this motion, which by omission has not been reflected on the order paper. And then thirdly, I've also been informed and I have received a copy of the excise duty amendment bill 2018. It's ready for processing, so I'll alter the order paper also to accommodate that so that we can also finish with that. Thank you very much. I have an urgent matter from Chua. I think the house is still in the state it was in yesterday. I don't know whether you want to proceed with it.
Thank you, the Right Honourable Speaker. Yesterday there was a procedural issue raised that the Minister, whom I was actually raising the matter of urgent importance to, was not in the House. But Mr. Speaker, I would just beg to continue. We cannot continue waiting for the Minister. Mr. Speaker, what I'm going to raise here affects the students, both girls and boys of Senior 1, Senior 3, in my SIT Senior Secondary School. Mr. Speaker, this SIT Senior Secondary School was started in the year 2010. But unfortunately, we have not had any support from the government up to now. It was actually the initiative of the community that were raising, the parents were raising 40,000 each and giving to sustain the school and to sustain even the teachers. But 2 days ago, Mr. Speaker, this school was closed and leaving about 48 students stranded, bearing in mind that we are actually in the middle of that term. And these students do not have anywhere to go. The 16 teachers who are operating that school do not even have anywhere to go. Mr. Speaker, I would like to request that the Ministry of Education intervene to save the fate of these students who are stranded, the 48, and also the teachers, as soon as immediately. I beg to move. Thank you.
Thank you, Honorable Minister. This matter came yesterday, but we were waiting for the Minister of Education to respond. Somehow we never got to his attention. It's an urgent matter. Students have been displaced. They don't know what to do. They have to sit in November, and their school has been closed. What happens?
Mr. Speaker and honorable colleagues, Mr. Speaker, I am requesting that the Minister of Education...
Mr. Honorable Minister of Education has just come.
Okay. Settles in a minute, and then he'll respond to this question immediately after.
Honorable Minister, when you were away, a matter came from Chua that a school which was a community school has been closed with the students who are supposed to be sitting this year. What happens to those students?
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I want to get in touch with the Honorable who is raising this matter so that I capture all the details, follow up, and ensure that the Ugandans who are in that school are assisted to continue with their education. Right Honorable Speaker.
Thank you very much. That matter does not come back here. Go and sort it out. Those students must sit. Those who are supposed to sit should sit this year. Thank you. Procedure.
Right Honorable Speaker, the procedural matter I'm presenting, I was here in July at the beginning of this term, demanding that the only city school in my sub-county of Kome is having no English teacher at all. The Minister of Education, who was there by then, promised that they are going to handle immediately, as they have also promised my colleague, But up to today, nothing has taken place. Again, Right Honorable Speaker and Honorable colleagues, I also came here with a matter of urgent concern. Today, when you see the National Planning Authority in the workshop where we are coming from, they are saying many students are dropping out of school. But one of the reasons, Right Honorable Speaker, is high fees from government-aided schools. I came here and I presented the matter to the Honorable Minister of Education, that how come all the indigenous, well-known day government-aided schools have been turned into boarding schools? And why do they charge high fees? To an extent, Right Honorable Speaker, that those day-code students, even to get a uniform, it is as if they are buying suits from these big shopping malls. A shirt and a trouser, they can demand 180, 170, which has become a problem to many of our parents. They promise that they are coming out with a structure of fees to help many who are now not even able to sit their final exams because of high fees. Right Honorable Speaker, is this not the right time to get the answer from the concerned minister? I thank you.
Thank you very much. Honorable Member, if you had looked at the order paper, and I was hoping you had, if you look at item 4.4, question raised by Honorable Muyanja, I suppose that is you, MP Mukono South, on the absence of teachers of English language in schools in Kome Islands. It's on the order paper for today. Thank you. Yes, you want to deal with another aspect, Honorable Minister, or we now proceed with our business of the day?
Thank you very much, Right Honorable Speaker, and dear colleagues. Honorable Speaker, about the teachers have already been recruited and posted to Kome Islands in this first quarter of 2018. About school fees, Right Honorable, a committee was set up to study and advise our ministry. A report has come out. We are now considering that report, and very soon we shall be informing the public about. I submit, Right Honorable Speaker.
Thank you. Thank you very much. Has he accepted the point of clarification?
Yes, I think so. Yeah. Yeah, thank you, Right Honorable Speaker.
Please,
on the school fees.
Please, Honorable.
Honorable, this is very important.
Well, he has not accepted. Please accept. Please, let's use the rules.
Right Honorable Speaker, I really request, I beg the government side. You know, Honorable Ministers, you are the people who normally guide us. And if you have any problem, it is you to respond. I really request, let me put this. Thank you, Right Honorable Speaker. Right Honorable Speaker, on the school fees, I remember last year, Parliament discussed this matter intensively about the 8 teachers levying very heavy school fees onto the parents. And Parliament tasked the Ministry of Education to rein on those schools so that they don't come up with another figure. Right now, what is going on, Right Honorable Speaker, you find a boarding school, parents are paying 1 million and above. And I do not know how they derive the figure of those school fees. Right Honorable Speaker, as we talk now, many children are chased away to look for school fees. This is third term, especially candidate classes. Those are in senior 4 and senior 6. And the parents are ever calling members of Parliament to bail them out. Right Honorable Speaker, this is a very important matter. Let the minister really take it very seriously. If not, then we are destroying the education system in this country. Thank you, Right Honorable Speaker.
Thank you very much, Right Honorable Speaker. Right, Honorable Speaker, the issue of school fees, as a ministry, we've taken it very seriously. That's why we put up a committee to carry out a study and advise us. As I said, Right, Honorable Speaker, the ministry has received that report. We are now considering it, and very soon the public will be informed. Even this House will also be informed. But we have also gone ahead to direct through a circular to all schools, asking them not to send away, not to deny student candidates the opportunity of sitting exams because of school fees. That's position number one. The other position we have taken, Right Honorable Speaker, is that in case, or before we come up with a position, in case there is a need to raise or to adjust the fees structure, that should happen only and only when the permanent secretary has studied the situation. First of all, the school management committee, boards of governors have held meetings and forwarded their request to adjust the fees structure to the permanent secretary, who studies the situation and either allows or advises otherwise.
Point of order.
Right, Honorable Speaker, the issue that is on table right now is very urgent. But when you look at now what the Honorable Minister is trying to tell us, that is in the future. Is the Right Honorable Minister in order not to come up with a clear order now that those students who are in government-aided schools and have been chased away because of fees, all of them go back to school and they close this end term of the academic year. That's what we are after. Is he in order?
Honorable members, I was listening to the minister very carefully, and he said they have written letters to advise the schools not to chase away students. But I think to ask the minister to set school fees right now on the floor here would be asking a bit much. But all I'm going to ask the minister is now, upon writing those circulars and upon the schools receiving them, have you ensured that no children have been chased?
Right Honorable, thank you very much, Right Honorable Speaker, for that wise ruling. Right Honorable, although we send out circulars to schools, copies are sent to all the stakeholders, including the district leadership or the local leadership, and we also follow up. We follow up and also encourage the public to report to us. And whenever cases have been reported, we have come in to help out. I submit, Right Honor.
So can you now take the advantage of the microphone to announce what the situation is to the schools?
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, today the senior 4 candidates who are sitting French have started their exams. And I want to use this opportunity to remind headmasters not to make a mistake of denying an opportunity to any of the registered candidates of sitting their final exams just because he has not been able to pay school fees.
Thank you. Thank you very much. Can we now proceed with the order? Honorable members, in the public gallery this afternoon we have a delegation of legal practitioners from various legal associations. They are here to observe the proceedings of the House. Please join me in welcoming them. You are very welcome. Can we proceed with the order paper now?
Order paper as amended, presentation of papers. Motion for a resolution of Parliament to authorize government to borrow up to $210 million from the Islamic Development Bank for financing the Mrekunye Apache Lira Acholi Bull Road project.
Is that the one? Minister, I thought the one of Rekunye Paj Acholebu was laid yesterday.
Yeah, it was done yesterday.
It was laid yesterday, and I referred it to the Committee of National Economy. It was received with an applause. The one that is remaining is the one where you needed to make an amendment on what was passed.
Oh, you want to vote on additional level votes?
Made a mistake? Honorable Minister, please proceed. Rekunye Apaj Lira Cholebu. Are you withdrawing what you laid yesterday?
Mr. Speaker, yesterday we did move to lay the papers for borrowing, but we have now cross-checked our facts. Actually, the request we made was in the same category with the next request, which we said that the changes, we had changes in the financing terms, and therefore we were seeking approval of the House only on those changes, not the entire loan, because we can now confirm that this House approved it and we got the resolution of Parliament. So it is in the same category.
Okay. So are we still laying documents, or we are proceeding with another motion?
So, Mr. Speaker and honorable colleagues, I now want to move a motion so that the House can approve the changes that happened in the financing, because this House had already approved the loan, but when we went back for one reason or the other, which I will state, that the changes of financing were amended, but they are not significant, but this House needs to be aware of them and approve of them. So I beg.
So what are you going to do with our rule 219, is it? What are you doing with our rule 219?
Mr. Speaker, I would request that we can handle another item on the order paper as we look at that rule, so that we don't take a lot of time for the House.
Okay, honorable members, those two matters which had altered the order paper to accommodate stood over, and let's proceed.
Item number 3, urgent questions under Rule 46. Item 3.1.
Minister of Works. Next.
Item 3.2.
Honorable Minister of Tourism. Three two is tourism, on the issue of the people who were killed in the game park. Next.
Item 4 on the order paper, questions for oral answer under Rule 42. Question 4.1.
Honorable Minister of Defense is not here. Next.
Item 4.2.
Minister of Gender.
Right Honorable Speaker, the Ministry did not receive the communication as per our rules of procedure, Section 46, so we request for the presentation to be done next week, Right Honorable Speaker. Thank you.
No, but Honorable Minister, this notification was given to you over 3 weeks ago. In writing. So I think let the records capture the truth, because you cannot say you had not been notified.
I thank you for your guidance, Right Honorable Speaker, and we request to present presentation about the money for the elderly in Parliament in 4 working days' time. Thank you.
Okay, can we defer this to next week?
Item 4.3.
4.3.
Right Honorable Speaker, I intend to respond to the issue that was raised by Honorable Nyango Gideon, MP Samia Bugwe North, during the 6th sitting of the first meeting of the 3rd session of the 10th Parliament of Uganda on the 12th of July 2018 regarding the concern that telecom companies require customers to produce certified copies of national identification cards from NIRA before SIM card registration is done. Right Honorable Speaker, before I respond, allow me to remind the honorable members that the policy objective behind SIM card registration was and is still to improve the safety of our nation by ensuring that all users of mobile phones are known and can be traced using the National Identification Database. As all colleagues may recall, the obligation to register communication service subscribers is a legal requirement under Section 9 of the Regulation of Interception of Communications Act of 2010. Under this law, every telecommunication service provider is required to ensure that all subscribers are duly registered before they are enrolled onto their communication networks. According to Section 66 of the Registration of Persons Act 2015 and Regulation 28(1) of the Registration of Persons Regulation 2015, the national ID is the primary legally acceptable identification document for every Ugandan who wishes to register a SIM card in his or her names. The mandate to issue national IDs is by law vested in the National Identification Registration Authority, which is NIRA, which is under the docket of the Ministry of Internal Affairs. Honorable Speaker and colleagues, following the surge in the number of crimes committed using mobile phones, including the rampant kidnaps and murders of several women, such as Susan Magara and the Entebbe women in March 2018, the Ministry of ICT through UCC directed all telecom operators to install biometric card readers such that all SIM card registrations and SIM swaps are done only upon electronic verification of the biometric details of the SIM card applicant. Right Honorable Speaker, the procedure for SIM card registration and replacement is as follows. All applicants for SIM card registration or SIM swaps or replacement must physically appear at the telecommunication operator's registered premises and will submit a valid original national identity card for Ugandan nationals, a valid original passport with a valid visa or residence permit for non-Ugandans. of valid original refugee card issued by the Office of the Prime Minister for all refugees. Number 2, all documents presented must be in original form to enable the said documents' security features to be read by the biometric card readers that are now used by all telecom operators at all their SIM card registration and swapping centers. Number 3, the electronic national ID card readers can only read the security features of the original national ID and not a duplicate or photocopy of the same. The card readers are designed in such a way as to pick up on all the security features embedded in the original national identification card. The information captured using the biometric card readers is instantly verified with the national identification database hosted by NIRA through the third-party application interface that was set up by UCC and the telecoms. This procedure is meant to eliminate fraudulent SIM card registrations. Right Honorable, the question now is, do telecom companies require SIM card applicants to produce certified copies of the national ID? My response is, Right Honorable Speaker, that with all due respect to my colleague, Honorable Gideon, it is not true that telecoms are asking customers to obtain certified copies of national IDs before they are allowed to register for SIM cards or to have their lost SIM cards replaced. Under the current procedure for SIM card registration, as highlighted above, there is no need for a person in possession of a national ID to present a certified copy of the same before they are registered. The application program interface, which was set up by UCC in collaboration with NIRA and the telecom companies, instantly verifies all original national IDs upon the card holder presenting the card and providing his or her fingerprints on the biometric card reader. In this process, there is no requirement for a person to produce a certified copy of the national ID. Honorable Speaker, perhaps my colleague's concern related to what happens to people who could have lost their national IDs. For cases of lost national IDs, Right Honorable Speaker and colleagues, the procedure is that upon loss of a national ID, the card holder should report to police, obtain a letter from police confirming loss of the national ID, and thereafter the card owner is required to report to NIRA for card replacement before the telecoms can allow them to register for SIM cards or to allow them have their SIM cards replaced. Honorables, Right Honorable Speaker, the challenge we have so far observed is this process. Is that this process relates to the time within which lost IDs, national IDs can be replaced by NIRA. It is reported that replacing a national ID takes approximately 3 months. This is certainly a long time, especially in situations where one needs to have an original national ID card to have their lost SIM cards replaced. Honorable colleagues, the technical teams in my ministry and NIRA are working on a practical solution through which lost national IDs can be replaced in a timely manner to minimize the inconvenience our people are currently facing. We guide, therefore, Right Honorable, that it is important that we all embrace these new measures that are being implemented by government to improve our national security. We should all encourage our countrymen and women to adhere to these measures for our own good. And where someone faces specific unique challenges in accessing these services, we encourage such customers to approach the responsible government agencies like NIRA, UCC, and the telecoms for specific guidance on how to go about these procedures. I beg to submit, Right Honorable.
Thank you, Honorable Minister. Supplementary question from the member who raised the issue. Are you standing in for him? Supplementary question.
Thank you, Right Honorable Speaker. Right Honorable Speaker, the Honorable Member is not around, but I communicated to him he said
Proceed.
Thank you, Right Honourable Speaker. Honourable Minister, we have seen in many occasions, you find someone asking the colleague to register the SIM card, his SIM card, but registered by another person. We have ever got this, Right Honourable Speaker, when someone has committed a crime, you find different name, the person is well registered, but somebody else is using that particular SIM card. Honourable Minister, what plan do you have to eradicate and stop such kind of acts? We have ever witnessed it in very many, and it's happening. Thank you.
Right Honourable, indeed that case has been reported. We remember the case that involved the death of Magara. Out of the so many people that were arrested, a few of them claimed that they were not even aware that their SIM cards had been, their names had been registered under different SIM cards. And it was a surprise to them that their names appeared to be under one of the SIM cards that were responsible during the communication that was gagged by our communication systems. So, Right Honourable, we are working on how we can sensitize the people on the circumstances that may befall them in case their SIM cards used by criminals. Right Honourable, after that sensitization, because many people, especially relatives, they've been helping other relatives to register SIM cards, unknowing that they can be used for criminal acts. And so we want to sensitize them that that is not right, and thereafter we are going to come out with penalties that will work as deterrent measures for those that will deliberately help others to register SIM cards. I beg to submit, Right Honourable.
Thank you. Next question.
Item 44.
Item 44, yes, Honourable Minister. Your colleague had already given a preliminary response to that, but you can proceed now.
Okay. Thank you very much, Mr. Speaker. Mr. Speaker, the issue raised by Honourable Miyanja Johnson Senyonga, MP Mukono County, South, on the absence of teachers of English language in schools in Kome Islands. Mr. Speaker, at Kome Secondary School in Kome Island, the approved staff structure is 21 teachers. Currently, there are 6 teachers, which leaves a gap of 15 teachers. It is true the school has no English teacher. However, the school has identified an English teacher and submitted his files to the Education Service Commission to regularize his appointment. However, this financial year 2018-2019, Mr. Speaker and dear colleagues, the secondary school subsector has received funding for the recruitment of 2,600 science and arts teachers, and out of which 1,500 will be science teachers and 1,100 will be arts teachers with emphasis on English language and literature. The chief administrative officers and the district education officers have been tasked to work with the head teachers in their districts to be able to identify the schools with the most critical needs to be beneficiaries of the imminent recruitment. Mr. Speaker, I beg to inform.
Supplementary question? You're satisfied? Thank you. Next.
Item 45.
Minister of Lands. Is it local government? Lands, yes, proceed, Honourable Minister.
Right Honourable Speaker, I just received an SMS message asking me to take charge but they were supposed to send me a response, which I have not received to date. So I want to beg you to allow us, as Ministry of Lands, to present next week, sir.
Is that how you take charge? Okay, defer to next.
Item 4.6.
Internal Affairs. Internal Affairs. Internal Affairs is not there. Today is Thursday, private members' time. Since we don't have this response, can we call another item from a private member before we come back to the formal business? Item 8.
Item number 8, motion seeking leave of Parliament to introduce a private member's bill entitled the National Legal Aid Bill 2018.
Member for Gulu Municipality.
Mr. Speaker, I stand here to present a motion seeking leave of Parliament to introduce a private member's bill entitled the National Legal Aid Bill 2018. And I move this under Article 79, 94 of the Constitution of the Republic of Uganda and Rules of Procedures 120 and 121 of our Parliament. Whereas Article 79 of the Constitution of the Republic of Uganda empowers Parliament to make laws on any matter for peace, order, development, and good governance of Uganda, and whereas the Parliament enacted its rules of procedure pursuant to Article 94(1) of the Constitution and Clause 4B of Article 94 and Rules 120, bestowing upon a member the right to move a private member's bill. Noting that the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the Convention on the Elimination of All Forms of Discrimination Against Women, 1979, the Convention on Rights of Persons with Disabilities, the Convention on the Rights of the Child, the Lilongwe Declaration on Accessing Legal Aid in Criminal Justice Systems in Africa, 2004, and the United Nations Principles and Guidelines on Access to Legal Aid in Criminal Justice Systems, all enshrined and emphasized the key principles of equality before the law, access to justice, and the provision of legal aid to those who need it to enable them effective assertion of their rights. Aware that it is the policy of the state and Objective 3.4 of the National Objectives and Directive Principles of State Policy enshrined in the Constitution to establish and nurture institutions and procedures for fair and peaceful resolution of conflicts and to promote a just and dynamic social order. Further aware that Article 21 guarantees equality and freedoms of all persons before the law, and it includes even the most vulnerable groups in society, and Article 28(3)(e), which guarantees the rights of every individual charged with a capital offense to legal representation at the expense of the state, and this right is inviolable under Article 44(c), and further noting that Article 26(2) calls upon the courts to administer justice to all, irrespective of their social and economic status. recognizing that the legal aid is a safeguard for the protection of rights, driver for social justice and the rule of law, a backbone for peace and development, as well as a foundation for the enjoyment of other rights, including the right to a fair trial, which guarantees fundamental fairness and public trust in the justice process. Concerned that over 80% of the people of Uganda, especially women and youth, are prevented by economic obstacles from accessing justice and from pursuing or defending their land or property rights and other rights before any court body determining civil, criminal, commercial, administrative, and social or fiscal matters. Whereas certain aspects of the legal aid services are embedded in the various legislations, such as the Poor Persons Defense Act, CAP 20, the Advocates Act, CAP 267, as amended, the Advocates Regulations 2007, that is on legal aid to indigent, and the Advocates Regulation 2004, purposely for students' practice, they are scattered, largely ineffective, and non-operational. Recognizing that, although Uganda lacks a state-funded legal scheme, there have been legal aid delivery mechanisms and models through both state and non-state actors, like the State Brief Scheme, Mr. Speaker, which I remember you diligently used to do, the Legal Aid Clinic of the Law Development Center, the Public Interest Law Clinic of Makerere University, the pilot legal aid programs such as the Justice Centers Uganda, paralegal advisory services hosted by the Foundation for Human Rights Initiative, pro bono service scheme of Uganda Law Society, and the non-state actors models such as the Legal Aid Service Providers Network, that is LAPSNet, and all are mainly urban-centered, donor-funded, and not sustainable. Convinced that in order to safeguard the basic right for all citizens to receive equal treatment in the course of asserting their rights and resolving legal disputes, there is need to enact a comprehensive and consolidated legislation providing an accessible, affordable, sustainable, credible, and accountable legal aid services to indigent persons in Uganda. Now, therefore, be it resolved that this House grants me leave to introduce a private member's bill for an Act of Parliament entitled the National Legal Aid Bill 2018, a draft of which I have attached here to do order the publication of the said bill in preparation of its first reading. Mr. Speaker, I beg to move.
Is the motion seconded? Seconded by PWD Eastern, Kabaramaido, County, Kachumbala, Kamwenge, Chua East, Youth National, Ndorwa. Would you like to speak to your motion?
Mr. Speaker, I move to speak to this motion in terms of giving justifications why this is very important for Uganda today.
I think the motion is very elaborate, so you are just...
I will see a way of how I do an executive summary of my presentation, but because I will be later on supported by none other than Gaberamaido to conclude my submission.
That would be my responsibility, not yours.
Well, Mr. Speaker, I request... Yes. Mr. Speaker, I start by giving our journey to achieving our development plan of 2040, the Vision 2040. Uganda committed itself to consolidate a secured and stable society operating on the principles of justice, equality, and the rule of law. The proposed law seeks to foster good governance through democracy, equal representation, equity, tolerance, constructive dialogue, and openness. Further, that the rule of law and the supremacy of the Constitution will be upheld to ensure that all individuals are subject and treated equally according to the law. In terms of issues of land conflict, the proposed law will address the land rights, especially for women in Uganda. Land is one of the most important assets held by poor households, largely. However, the process of land acquisition to date is predominantly conducted through inheritance, and in a patriarchal setting, women are less likely to inherit land or other resources from their own family or from their husband. Land disputes are everyday occurrences in Uganda, and in some instances, these disputes result in clans conflicting with vulnerable groups such as women and children relatives. According to the 2013 National Governance Baseline Survey, at least 2.3% of adults reported having had land dispute in the 12 months prior to the survey, and this translates to 95,300 land cases annually. The Case Backlog Reduction Committee report of 2017 indicate that land cases pending at all levels of court are ranked the second highest at 33%. The land matters feature prominently among cases handled by legal aid service providers, standing at 49%, accordingly to the Legal Aid Service Providers Network Information Management System of 2018. The same study also shows that half of the land-related conflicts involve family members, either the head of the household or the spouse's family or other relatives. Apart from family-related conflicts, land appropriation by powerful, well-connected individuals has been associated with evictions. Forceful evictions have in some instances resulted into death among warring parties. This affects the overall land tenure security across the country and affects development as the threat of eviction impacts on realized investment on land. Mr. Speaker, besides, it exacerbates social exclusion, given that some of the affected groups, widows and orphans, are the most vulnerable section of society. Finally, a substantial proportion of the transfers of properties do not have documentary evidence, and this can result in different interpretations of wills. 3 is on issues regarding vulnerable group support to access to justice. The provision of legal aid is a key to access to justice. According to the World Bank, the availability of publicly provided legal aid services, especially in developing countries, is associated with minimal occurrences of due process violations and the reduced duration of both pretrial detention and case resolution. Legal aid is targeted at vulnerable groups, such as women and children, who generally face impediments in accessing legal aid services, legal services. Evidence also shows that the legal aid services to such vulnerable groups reduce social exclusion and increase the likelihood of family maintenance and reduction in recurrences of domestic violence.
Honorable Member, you are proceeding as if you have already been granted leave.
Well, let me now.
Because you are now speaking to the bill as if you have already been granted leave.
Okay, let me give the highlights.
What you are doing is, you are asking this House to give you permission to present what you are saying now. So you have not yet been allowed to present what you are saying now. So can you tell us why we should give you leave? There should be gaps, there should be what, and all those things. The way you presented the motion was sufficient because...
Mr. Speaker, I had earlier raised these justifications why I should be granted this.
Your justification is now to the bill, not to the motion for leave. That is the speech you will give when now you are speaking on second reading of your bill.
Mr. Speaker, as far as I'm concerned, I think I have fundamentally given reasons why I should go on leave. And of course, there are other legal contexts I had wanted to refer to that also give more of the reason why we should proceed. Because at present, if you look at access to justice, Mr. Speaker, let me speak of CAF. If you look at the level of access to justice in this country, from independence to date, the gap is too high. Justice is seemingly for the rich. the poor percentage of Ugandans who should be having equality before the law do not have this access. And here we are saying, we have over 80% of Ugandans who are there. The law allows that we are equal before the law. But to what extent should we have substantive equality before the law? That will be in a way that if we bring this to this house, I think a lot will be done for Ugandans. The poor, as we speak now, always just rotate around court premises because they have no formal legal representation. With this law in place, we shall even be reducing the burden of members of parliament who at all times are on standby to be handling on behalf of their constituents some of these issues. And that is why I felt it is very important to request this House, humbly, Mr. Speaker, so that I proceed with this serious work and I come back and submit at length what is important for this country, Mr. Speaker.
Thank you very much. I think I'll allow the second of the motion to speak before I propose this motion for your debate. Member for Kabaramaido.
Thank you, Mr. Speaker. I stand here to second the motion for a resolution of Parliament to introduce a private member's bill entitled National Legal Aid Bill 2018. Right Honorable Speaker, the reasons are many, but I just want to justify that the legal aid definition is actually entrenched in the law itself. That is in our Advocates Act, the Advocates Legal Aid to Indigent Regulations 2007. I also want to support it by the justifications that the legal aid is recognized internationally in our international law and policy, and these are international laws that Uganda has signed, so we cannot get away with it. They've all been adopted by our state party, Uganda, and these are the Sustainable Development Goals. We have the International Covenant on Civil and Political Rights. We have Article 40 of the Convention of the Rights of the Child, 1992. We also have Article 12 and 13 of the Convention on the Rights of Persons with a Disability. And then we have the African Charter on Human and People's Rights of 1986. So that is as far as the international laws are concerned. Now, coming home to the national laws, our national legal framework supports legal aid. We have the Constitution of Uganda, 1995, that is Article 21. We have the right to legal representation, Article 28. We have the right to a fair hearing, which is both Article 28 and Article 44. And Right Honorable Speaker, Article 44, the right to a fair hearing is a non-derogable right. We also have the Poor Persons Defense Act, Cap 20. We have the Advocates Act, Cap 267 as amended, and this has already been mentioned. We have the Advocates Legal Aid to Indigent, which I've already mentioned. We have the Advocates Students Practice Regulations 2004. And then we have the Uganda Law Council, which is a body which is empowered to inspect, approve, regulate service providers of legal aid in Uganda under the Advocates Act, Cap 267. Now, why are we really concerned about, why are we requesting for this law? Right Honorable Speaker, the law is scattered all over. What we are really asking is that the practice, the activities that are being done by the NGOs, being done by other institutions and the civil society be consolidated under one national law. For example, we have the state brief scheme, which is Article 28 of the Constitution. We have the legal aid clinic of the Law Development Center that is putting a drop in the ocean. And then we have the legal aid clinic of the Justice Centers of Uganda. They are also trying their best. We have the paralegal advisory services, and then we have the pro bono service of the Uganda Law Society. Finally, we have the Legal Aid Service Providers Network, LAPSNet, which is a group of about 50 civil society actors. Here, FIDA Uganda is included. We have the human rights activists and others all included. So they are scattered. What we are asking for, and Right Honorable Speaker, when you hear us speak with emphasis, it is because it is important. We need to actually put these pieces of actors, pieces of the laws in one house so that they can be administered under a national scheme. Therefore, Right Honorable Speaker, it is important to take cognizance of the fact that while the legal framework for the provision of the legal aid is in place, the law is scattered, as I've already mentioned, and then we wish to have these laws consolidated. I therefore, Right Honorable Speaker, submit that leave is granted for the motion for the resolution of Parliament to introduce this private members' bill called National Aid Bill 2018. I beg to submit.
Thank you very much, Honorable Member for Kabaramaido, for your speech in secondment of this motion. Honorable members, the motion that I now put to you for your debate, the question I propose for your debate is that this House grants the Honorable Leandro Komakech, MP, Gulu Municipality, leave to introduce a private member's bill entitled the National Legal Aid Bill 2018. That is the motion for your debate, and the debate starts now. And honorable members, we don't want to start debating the principles of the bill. We want to interrogate the question as to whether what he's proposing is sustainable by constitution and by law, whether it is not prohibited, financial implication, creating a one-party state, or retrospective legislation which are prohibited by the Constitution. Those are the areas we need to investigate and see if we can grant this member that leave. I'll start from Kampala Central. Before we start, honorable members, in the public gallery this afternoon, we have pupils and teachers of Mount St. John's College, Kagoma, Representative Honorable Wale Omo Moses and Honorable Katani Lloyd. They're here to observe the proceedings. Please join me in welcoming them. Thank you. Yes, Honorable. Can we use 3 minutes each?
Thank you, Right Honorable Speaker. And I would like to rise up in support of the motion to grant leave to the Honorable Member from Gulu Municipality to present a bill that shall entitle people seek legal aid in order to see to it
that they have justice. Right Honorable Speaker, Article 28 of the Constitution embodies unto us to grant people a fair hearing in all trials. With the prevalent poverty, Right Honorable Speaker, people can hardly seek counsel from all ends without support of legal aid. When we empower them as Parliament through legislation, it shall enable the poor, the rich, and those that are moderate bridge a gap between access to justice and denial of justice. The bill shall have no financial implication, for government has no cost to draw from the taxpayer in order to support the legal aid bill. I'm therefore stating clearly and trying to plead to all members of this House and persuade you to grant the honourable member from Gulu municipality leave to present this bill. Thank you very much, Right Honourable Speaker.
Thank you. Ajuri.
Right Honourable Speaker, I rise with your submission to submit in support of the fact that members be persuaded to grant leave to the mover and the seconder of this very important bill. I say this because in 1992, the Uganda Law Society established the Legal Aid Project. And that project in particular helped especially the group we are talking about. Secondly, Mr. Speaker, I am also alive to the fact that as we speak, we have already developed through the justice, law, and order sector, the national legal aid policy. What now remains is the legal framework to operationalize it. We must salute the member for Gulu municipality for exercising his constitutional right ahead of the line ministry to seek for permission to present a private member's bill to operationalize the policy. And on those two notes, I submit and persuade other members of Parliament that let's grant leave to our very own member for Gulu municipality, supported by the member from Kaberamaido, such that the national legal aid bill for Uganda is formally tabled and we enact it into law. Thank you.
Thank you very much, Right Honourable Speaker. I rise to support the motion. I am aware of the provisions of Article 93 of the Constitution, but this particular motion will not in any way offend those provisions, since the state itself has been engaged in the provision of legal aid, but restricted to the criminal justice system, particularly in cases where the penalty is either a death sentence or life imprisonment. And the resources the state has been injecting in that aspect can be maintained at that level. Secondly, Right Honourable Speaker, the question of access to justice is fundamental to both the social, political, and economic development of this country. And it is paramount, especially in respect of our people in rural areas who cannot afford the services of advocates, the women, the children who are in conflict with the law, and the rest. And recently, there has been an emergence of various legal aid service providers who have no regulatory framework. It is important that these legal aid service organizations who are non-state actors be regulated in such a way that the services they render are controlled by the state. And it is for those reasons that I support the movers of the motion and invite members to support this motion and grant leave to the movers to bring the private members' bill. I so pray.
PWD Eastern, then PW Central. Let's start with Eastern.
Okay, thank you, Right Honorable Speaker. I stand to support the motion for the private member to draft a private member's bill entitled National Legal Aid. Right Honorable Speaker, there have been efforts to support people who are vulnerable, and I represent people who are vulnerable, the disabled people, including the blind. I am also chairperson of Equal Opportunities Committee, where you find issues of minorities. These are people who never get justice and really need support of government to ensure that they get justice. So this legal framework is timely and will come and help our people. Because we know that when the Uganda Legal Aid Services come maybe at the Constitutional Square, it's about a week, and then again it goes away. It doesn't go to the whole country. So I want to call upon the House that this is something that will go a long way to support our people who are vulnerable, the children, the women, the orphans, so that they can get justice. And Uganda is a signatory to many of these laws. I quote the Sustainable Development Goal number 16, which talks of access to justice. I think we all support the Honorable Member of Gulu Municipality and the Honorable Member of Kaberamaido County to move and bring the bill, and we shall give the support it deserves. Thank you, Right Honorable Speaker.
Thank you. PW Central.
Right Honorable Speaker, I congratulate the honourable member for moving this very important bill, and also declare that I do support you. Right Honorable Speaker, we should not forget that this is a private member's bill. Also, we should not forget that we have had good experience in relation to processing a private member's bill. Good experience and sometimes bad experience. Right Honorable Speaker, through you, I would like to remind the August House that the law requires that a member moving a private member's bill is accorded reasonable assistance by the Attorney General, by the Office of Attorney General. I'm so happy the Attorney General has just come. So, Right Honorable Speaker, I request you to ask the Attorney General to put it on record that he will be prepared to give our colleague the reasonable assistance required. Second, Right Honorable Speaker, the law requires that the Minister of Finance provides a certificate of financial implications. Through you, I beg you to ask the Minister of Finance to inform this August House to put it on record that he's going to provide the required certificate of financial implication. Thank you so much. I support the motion.
Buyaga.
Thank you very much, Right Honorable Speaker. And honorable members, I beg to support the motion seeking leave of the House to present this bill, private members' bill, on the principle that all Ugandans are entitled to fair hearing, and being the chairperson of SDGs, where SDG 16 requires that all people should not be left behind by SDG number 16 on matters of justice, accessing justice. I would think this bill, if brought to the House and enacted into law, will go a long way of solving that problem. Right Honorable Speaker, I want to At one time, I went to court to stand a surety for someone. Where I reached there, this person was not represented by an advocate, but the other party was represented by an advocate. The advocate of the other party, I think it was the state. The state made their case and they were trying to resist granting of bail. Just as I started thinking, if this person was really represented by an advocate, would the state be making these arguments? I had to actually stand as a surety and remind the magistrate that, Your Worship, this man is not represented by an advocate, is not represented in this matter by an advocate. And I had to say, you know, the Constitution requires your office to administer justice without undue technicalities. And the argument they were looking at was that I had not carried a LOC1 chairman's letter to be identified in court. I pulled out my ID. They said, no, we don't need your ID. But the law requires that a national figure like me, you can take judicial notice. And these are matters which I think an advocate should have raised, should have put to the bench. And I'm sure as much as we succeeded in rescuing, in him getting bail that day, I think it was some kind of a protracted fight to get him bail. And I am so sure that there are many people outside there who are denied substantive justice and fair hearing, which is a non-derogable right, according to the Constitution of the Republic of Uganda, Article 44, because they are not represented. And this seeks to make sure that venues will be put in place where at least a person can be sure that I will have somebody to represent me if I choose, and the offices will be noted, and the people can walk in and pick an advocate. Thank you very much, Right Honorable Speaker.
Thank you. Gomba.
Thank you, Right Honorable Speaker, for the opportunity. I would like to stand up to support the motion, to support the bill, the introduction of the private members bill, because legal aid is something that is very important for our indigent people. In 1990, FIDA Uganda came up to open one of the first ever legal aid clinics in this country, and the service that has been offered at that legal aid clinic has been really immense and has helped the women and children of Uganda. And I know that many times the ordinary being is intimidated by the fact of going to a lawyer's office and seeking for legal help. In terms of them accessing the office itself, but also in terms of the finances that they are going to pay. It is believed that legal services are expensive. They are indeed, but interfacing with a lawyer is difficult for some of them. So there are many legal aid clinics that came up thereafter, Uganda Law Society being one of the most immediate, and others that have come up now. And there is a need to coordinate those services so that we have an organized legal aid scheme in the country. So for those reasons alone, I do support the fact of the private members bill coming up. Thank you.
Honorable members, I need to hear from the Land Attorney General, if there are any. Land Attorney General?
Thank you very much, Right Honorable Speaker, and honorable members. Of course, the question of legal aid is the desire of everyone. both government and opposition. At least it ought to be. And my office has informed me that we are actually working on it. I think the honorable member, the Honorable Obua, reminded the House that together with JLOS, we are working on the policy. You cannot bring a law, ordinarily it should be underpinned by a policy. The policy is more or less ready. The problem is, I had a member say that there were no financial implications. Of course there are financial implications, and big ones, because a national aid as a general scheme is not necessarily free legal aid, but it is legal aid that has been financed by the government. And therefore, there are financial implications. Happily, the Minister of Finance is here, and I think, I don't specifically want to oppose your presentation, except to say that it is a good idea that you come to our chambers. We can request the House for a specific time period, because we are quite serious. We are quite serious on that. Because and then we harmonize, because you may have some very good ideas.
Point of order. Point of order.
Right Honourable Speaker, the legal aid policy has been advocated for the last 10 years. Law Development Society, we have Law Development Center, Uganda Law Society, LASPNet as a private non-state actor. And Right Honourable Speaker, as we speak now, actually a copy of that policy is already in cabinet. Now, is it therefore in order for the minister to drag us back and say the person seeking leave, the Honourable Kumaketli Andro, should first go to his chamber and they agree on when to introduce this particular law that will actually actualize a policy which is already lying with the cabinet? Is it in order to backtrack us on this particular issue of importance that makes the end of justice meet for the poor of the poorest? Thank you, Right Honourable Speaker.
Land Attorney General, that is the bit that I have to do myself. Honourable members, we pass laws to facilitate things in this country. The provision of the Constitution is clear. The point of order is raising whether the Attorney General should say what he's saying. And I think he has every right to say what he's saying. And I like it that he didn't say he was going to oppose the request per se, although he also hints that there are financial implications. Like I asked at the beginning, there are limitations to how a private member can proceed with these matters. If, for example, you touch on Article 44 and you're proposing a bill in that line, it will not be permissible. If you touch on Article 75, you want to create a one-party state, the Constitution will not allow you to do that. And if you want to bring legislation that has retrospective effect, neutralizing judgments of court, the Constitution will not allow you that. And so this House will not even allow you that because the law does not permit that. And if you're introducing a proposal that has a direct charge on the consolidated fund, then you call into action the provision of Article 93 of our Constitution. So these are real things. The question is, how do we move forward with the proposal that has been made instead of trying to stop it? Or because it raises an important point that there is bound to be financial implication if we are going to finance a legal aid scheme in the country. The question is, does that call into action the provision of Article 93? And the answer is yes. But now how do we move from here? How do we move from here? Honorable Komakech has made the point, has called the shot, the policy is in place, but the Attorney General is sitting on it, is not bringing it to the House, and it's only today that he is now telling us of the existence of a policy. He has been sitting on it for years. Is it possible for him to come and make a commitment here? Then we see how to harmonize, how to proceed with this matter.
Thank you very much, Right Honorable Speaker.
It's part of the procedure still. I want to listen from him. I want to listen from him. Please. No. I want to listen from him. I'm going to rule. I'm still going to rule on this matter, so let him first finish.
Thank you very much, Right Honorable Speaker and members. As I was saying, I was requesting that the member came to my office, to our chambers, and that's the Ministry of Justice and Constitutional Affairs, and we harmonize. I wasn't saying that I was opposing the bill. As for the question of how long it has taken, well, I'm now saying it is going to be done. I am impressed that the member knows what's happening in the cabinet, because I often sit there, and he's saying that the bill is there, but that means if it hasn't been presented, I am saying that if we can harmonize, then we can present and then come here after including whatever the honorable member has to add. And I was alluding to the fact that I'm quite happy for us to give it a time frame so that I leave no gray area. So, Right Honorable Speaker, if you gave us 30 days, within which I can harmonize with him, and then we bring it back, or subject to your guidance. I thank you.
Procedure.
The procedure, Right Honorable Speaker, I had wanted you to guide us on. The right to learned, the Attorney General is submitting that he would want to move harmoniously with the mover of the motion by first presenting the policy. To me, I find that he's taking us back because, first of all, they are already doing legal aid in the criminal justice system, where somebody is charged of a felony that carries death sentence or life in prison. I don't know under which policy they are doing it. It is provided in the Constitution of the Republic of Uganda. So, to hold a member of parliament who has spent nights, days, reading, doing research, and also moving the house to give him just leave, that we first wait for the minister who has very many other issues. I would think, Right Honorable Speaker, that it would, is it procedurally right, given the circumstances that one, they are already doing it in the criminal justice system, it is provided for by the Constitution, under the circumstances of a felony. 3, that the honorable member has really invested in a lot of time in moving us just for permission. We hold him because the Attorney General, the learned Attorney General, is not ready. Is it procedurally right for us to proceed that way?
Honorable members, I asked some guiding questions at the beginning, that what we are assessing now is what is important. Honorable Leandro Komakech, how do you propose to finance the legal aid scheme proposed by this law? How do you propose to finance it?
Mr. Speaker, we already have a rolling model that is in place.
How do you propose to finance it in the bill?
Through budget, Mr. Speaker, because already if I have to give a bit of background.
Through the budget?
Pardon?
Through the budget?
Yes, please.
Okay, if it's through the budget,
yeah,
then you call into action Article 93 of the Constitution.
Okay.
If you are using the budget to finance it, then it brings into play Article 93 of the Constitution. So the question that we should ask is, can Parliament proceed to grant you leave to proceed with a motion that has this effect? Would it not be in vain? That is the question we are proposing. Would you go with what has been proposed and then see how to bring this matter? You have achieved already by bringing this.
Mr. Speaker, I respect the Attorney General. What I was proposing is that my request for leave was to facilitate us to now go into the domain of this discussion with the minister. So, because I shall have been given some weight by Parliament to engage the ministry. I have competency in research in this country for 10 years on social legal studies. And I would be actually reboosting the ministry by working together, by catalyzing their energy to ensure that we come back to this house as fast as possible. And mine is not to say I oppose what he says, but I would like him and myself to have what we call the lowest common multiple in mathematics, that is common denominator, so that we simplify some of these issues. Parliament grants me leave, and then we work together, and possibly, I anticipate the ministry will now come as the front to proceed with this.
The question is, honorable members, we don't need to spend time on this. The question is, can you grant a member of Parliament leave to present what is prohibited by the Constitution? Can you do that? The answer is no. So let's go with what has been proposed by the Attorney General. That from now on we recline and give the Attorney General a timeline within which to bring this bill that he says he already has. That now will be coming a proposal from the government. Okay? Land Attorney General, when are you bringing this bill so that we can do the consultation?
Thank you. I also wanted to correct the member that the current legal aid scheme does not apply to felonies. If you know the category of criminal matters, felonies is way below the category of murder. It is only provided for in murder. And the reason is because murder is the highest crime that you can find with a person. And the law is that for a person for whose life you're going to terminate, give him the best effort possible under the country's constitution. So, sir, it is only murder for which there is the legal aid scheme. Now, the national legal aid scheme that he's talking about is to encompass everything else, I suppose. Just like the one you said you were trying to stand for somebody who wanted bail, yeah. And that one must entail financial implications because, as I was saying before I was earlier interrupted, when you talk about national legal aid, it is not necessarily free. It means that some lawyers will be got and we will be paying them. Government will be paying them, but at a reasonable rate. So all I am saying is, Right Honourable Speaker, I was just correcting the facts, but I was saying that if you gave us 1 month, I think it's a good idea to be reasonable, especially after somebody said it had taken 10 years. I will harmonize with the Speaker, and I undertake that we will bring it before this House. I thank you, sir.
Honourable members, you see, 1 month is okay, because even if you grant the Honourable Yando Komakech leave to present, he will not present tomorrow. He'll still need to go and prepare the bill and then go gazette it and come back. It could also take about the same period. So, honorable members, we will pause this motion here because it's not, it's not sustainable in view of Article 93 of the Constitution. The member proposes to finance his proposal when it is by a budget, and that means financial implication. But it has ignited the process of making this bill come before this House. That's the important thing. Let's give the Attorney General 1 month within which to come back to this House for the first reading of this particular bill. Thank you. Next item.
Order paper as amended, bill second reading.
Are you calling the title?
The Excise Duty Amendment Bill 2018.
Honorable Minister.
Mr. Speaker and honorable colleagues.
Honorable Minister, just let me recognize these children might be going. In the public gallery this afternoon, we have pupils and teachers from Oyam Junior Day and Boarding School, represented by Honorable Okello Charles Engola Majoduogo and Honorable Alum Santa Ogwang. They have come to observe the proceedings. Please join me in welcoming them. Students from Uyam, you are very welcome. Thank you. Honorable Minister.
Mr. Speaker, I beg to move that the bill entitled the Excise Duty Amendment Number 2, Bill 2018, be read the second time.
Is the motion seconded? Is the motion seconded?
Yeah, overwhelmingly.
Overwhelmingly. Seconded by member for Kanungu, member for Chegegwa, member for Koboko, member for member for Nakaseke, member for Bujenje. Would you like to speak to your motion?
Mr. Speaker and honorable colleagues, the Excise Duty Amendment Bill Act 2018, which became effective on 1st July 2018, had introduced, among others, the 1% of the value of mobile money transactions on receiving payments and withdrawals. And during that month of July and August, we reviewed it and came back to this House to reduce it from 1% to 0.5%. But this time, not on receiving payments and withdrawals, but only on withdrawals. So the bill seeks to amend the existing 1% to 0.5%, but only on withdrawals. Colleagues, as you know, our tax effort stands at only 14.2% of GDP, yet our expenditures on development priorities, which we did pass in this House, and I must say, Mr. Speaker and honorable colleagues, that these resources out of the 0.5% have actually been already appropriated by this House. So these development priorities now stand at 22% of our GDP. As a result, we are forced to borrow domestically and externally, and sometimes incur high interest costs, and increased borrowing means the increased debt burden. So we therefore need to increase our tax revenue mobilization to promote self-reliance in financing our programs and at a least cost of borrowing. So the main objective of this 0.5%, among others, is to raise 115 billion to finance the expenditure priorities that this Parliament appropriated. I also want to inform colleagues that the total value of mobile money transactions in the financial 2016-17 was estimated at 63 trillion, according to the Central Bank of Uganda. And the number of transactions in the financial 2016-17 was estimated at 1.2 billion. If we discounted the value of the mobile money transaction by 65%, take account of possible repeat transactions, errors and omissions, and compliance, the taxable value would be at 22 trillion. We also want to inform members of this House that our GDP as we speak is close to 101 trillion. 101 trillion. Out of that, the value of transactions of mobile money stands at 63 trillion. But the tax on mobile money and these telecom companies, we only get 57 billion. So out of the value of mobile money transactions, which count 63% of our GDP, we are only receiving 57 billion. Mr. Speaker and honorable colleagues, when the 1% levy was introduced, the public came out, members of parliament made comments, and because this government is a listening government, we listened to the people of Uganda, and we reduced not only from 1%, but from 1% to 0.5%, but only on withdrawals. Only on withdrawals. Mr. Speaker, when the 1% was introduced, there was a technical hiccup which imposed a tax on deposits. And that one has been already rectified and people have been refunded. If they are not, they are in the process of refunding. They should be. They should be. That is, yes. So, Mr. Speaker, one of the justifications that we have is to capture, colleagues, is to capture the majority of unbanked Ugandans who are largely in the informal sector, but using the mobile money platform to conduct their businesses and financial transactions. This will help government to expand the tax base. We have a number of informal businesses, informal transactions, who are using mobile money, but they are not within our tax base. And this tax measure will help to capture those transactions. And above all, Mr. Speaker, it is a duty of all Ugandans, it's actually not only a duty, but a constitutional duty, that all citizens must have a small contribution to make to the development of their country. And therefore, it should be understood it should be understood that this tax is not a punishment, that it is an opportunity for every citizen who is within this bracket I've talked about of transactions to make that small contribution to enable government extend the electricity that they need, to build health centers they need, to build the roads that they need, and finance all the expenditures, including our own expenditures here. With that, Mr. Speaker, I beg to move and I seek the support of every member to support this important tax measure. I thank you.
Procedure, Mr. Speaker. Sorry, Mr. Speaker. Mr. Speaker, I'm rising here on a procedural matter. Last time when we passed this law, the Honorable Minister, Honorable Bahati, did present again and read the figure of 1%. But after we had passed, the senior minister, who is again not here today, went on the press to deny and accuse Parliament. Even members, Right Honorable Speaker, even some members went ahead to castigate you because you are in the floor. Yet, the minister was represented here by the Honorable Minister. Today, again, he's not here. What guarantee do we have that tomorrow, Honorable Kasaija, the Minister, State of Finance and Economic Development, will not turn around again and accuse members of Parliament that is not what we have agreed, given the fact that he's not again here today. So is it procedural right for us to proceed without the presence of Honorable Kasaija, whom we have known not for once, not twice, but 3 times of turning around and coming and accusing Parliament and abusing them as that? So is it procedural right for us to do without his presence here today? Right Honorable Speaker.
Honorable members, where I come from, an apology is supposed to neutralize whatever wrong had happened. But doesn't mean you should forget it. An apology makes you at peace with the mistake that had been made, because the person owns up and says, please forgive me, I made a mistake. But doesn't mean that you should forget it. The information I have is that the Honorable Minister, the Senior Minister of Finance, actually is not well physically. Yeah, that's what the information I got. He's not well. Let me leave it at that. So to ask him to show up here, we might need another week or 2 for him to come. But honorable members, the Honorable Minister was here, the Senior Minister was here, and he apologized to the House. I remember I was the one presiding when he gave the apology to the House, and we accepted the apology. So let's operate on the basis of that. And I'm sure if that Honorable Minister who rendered that apology here remembers what happened, he would not do anything else, because he knows exactly what happened. I don't think he wants to face the same music twice. So, honorable members, I'll propose the question for your debate. The motion that I propose for your debate is the motion that the bill entitled the Excise Duty Amendment Number 2, Bill 2018, be read the second time. That is the motion before you, and as usual, to kick off our debates, we refer to our committees who have interrogated this matter to advise us and guide us on how we debate this matter. Chairman.
Thank you, Right Honorable Speaker. Right Honorable Speaker, the Committee on Finance, Planning and Economic Development considered the Excise Duty Amendment Bill number 2, 2018, and would like to make the following observations. Mr. Speaker, our observation number 1 is that the public debt to GDP is on the rise and now close to 40% in nominal terms for the financial year 2017-18. In addition, government paid Uganda shillings 2.586 billion in interest payments in the financial year 2017-2018. The developments are a result of raw revenue collections, about 14.1% of GDP, against expenditure pressures of about 22% of GDP, leading to a fiscal deficit of about 5.6%. In order to manage this increasing debt burden pressures, it's paramount to increase our revenue mobilization efforts through widening the tax base. Mr. Speaker, the current budget of 32.7 trillion that was approved by Parliament in May 2018 was premised on the national priorities and financing framework, which includes tax measures. This therefore implies that any negative effect on the tax revenue will jeopardize the implementation of the budget. It is important to note that the government cannot borrow any more from the domestic market beyond shillings 1.963 billion. Mr. Speaker, the Excise Duty Amendment Act 2018 imposed a 1% levy on receiving, withdrawal, and payments of mobile money transactions. The effect of this tax was 1. A decline in total turnover in mobile money transactions by 30%, which directly affects the withholding tax collection. 2. Mobile money agents dropped by 40%. This has rendered the majority of the people employed in the sector jobless. 3. Loss of public trust in the mobile money system. 4. Principally, since the bank transactions are not taxed, makes it discriminatory among others. Additionally, implementation of the 1% tax on mobile money transactions was met with some challenges, which include misrepresentation of the excise duty law, which resulted in the taxation of deposits, which was not the intention of the law. Government worked with the Uganda Revenue Authority to inform the public and telecom companies not to collect the tax on deposits and use of mobile money for payment of taxes. Observation number 4, Mr. Speaker, the transaction fees charged by telecom companies are shared with government agents, and part of it is retained by the telecom companies to meet operational costs and profit margins. 10% of the transaction fees is paid to government as tax, 50% is paid to commission agents, and 40% retained by telecom operators, respectively. The proposed 0.5% tax will be charged on withdrawal of cash transactions only through mobile money. Its main objective is to generate revenue to finance the budget. The projection from this measure is estimated to be 115 billion. Despite Uganda having a free market economy, where prices of goods and services are determined by the forces of demand and supply, the committee noted that transaction fees on mobile money platforms were high compared to other service providers in the similar business. This is partly due to lack of consumer protection laws that have left citizens exposed to multinationals. For example, telecom companies, Mr. Speaker, charge 119,800 shillings on withdrawal of 1 million shillings. The imposition of 0.5% tax on 1 million shillings will amount to 5,000 shillings. Compared to the 19,800, Mr. Speaker, charged as fees by telecom companies. There is no comprehensive legal framework regulating mobile money payments in Uganda. The sector or industrial regulation is based on guidelines issued by Bank of Uganda in 2013. These do not address issues like next of kin on dormant accounts, accrued daily interest payments, among others. Government should enact a law to regulate mobile money transaction payments. The committee would like to recommend, Right Honorable Speaker, that number 1, a law to regulate mobile money payments be put in place. Number 2, consumer protection laws be enacted to protect citizens from high costs charged by multinationals. Number 3, Uganda Communications Commission should analyze the components and formula used to determine the transaction charges with the aim of reducing them. Lastly, Mr. Speaker, the Excise Duty Amendment Bill number 2, 2018, be passed into law. Mr. Speaker, with your indulgence, I am made to understand that some of our colleagues in the committee came up with a minority report, and I would like to beg your indulgence that we allow one of them to present the minority report on their behalf. Right Honorable Speaker, before he comes, I would like to lay on the table the original copy of the committee report duly signed by more than the required members, together with the minutes and all the documents that were submitted to the committee during the consultation process. Thank you so much. Right Honorable Speaker, I beg to move.
Let the records capture the reports and the minutes of the meetings of the committee. Honorable member who is moving the minority report, please present the minority report. There's a minority. Please, can we receive the minority report, please?
Right Honorable Speaker, I have tried to access both what he was reading and also what he's referring to as a minority report. Both of them are not uploaded. Where? They are telling me I have not paid the OTT. So maybe I wait and have to debate whether this OTT should stay or.
Right Honorable Speaker and honorable members, Committee on Finance, Planning and Economic Development present a minority report on excise duty amendment number 2, Bill of 2018. Right Honorable Speaker, Parliament in May 2018 passed the excise duty amendment 2018 bill that was assented to by the President on 21st June 2018 that introduced excise duty of 1% on the value of mobile money transactions, of receiving payments and withdrawals. This tax, however, made serious criticisms.
Honorable, why don't you go to the area of that's the same thing that was read by the committee chair. Why don't you go to an area of dissent?
All right, Honorable Speaker, let me go to the area, our areas of dissent. Our areas of dissent, Right Honorable Speaker, I know time is not on our side. Levying of tax of excise duty of 0.5% on the value of mobile money transactions on withdrawal of cash. That's 2.0. Then 3.0, dissenting observations. The committee interfaced with various stakeholders from Ministry of Finance, Planning and Economic Development, banking sectors, telecommunication operators, civil society organizations, and a member of law fraternity, private sector foundation, mobile money dealers, and a member of parliament from Busiki County constituency, Honorable Akambapo. Their submissions were summarized as below. Bank of Uganda. These are the stakeholders. In their submission, they highlighted that the tax is neither neutral nor equitable between businesses engaged in similar forms of activities. The same tax does not apply to withdrawals from banks and microfinance institutions or circles. Equity is an important consideration, Right Honorable Speaker, within a tax framework. Equity suggests that taxpayers in similar circumstances bear a similar tax burden. They further observed that the value of mobile money transactions declined by 672 billions in the first 2 weeks of July 2018 compared to the first 2 weeks of June 2018, in part following the announcement of the Excise Duty Amendment Act 2018, introducing a tax of 1% of the value of transaction that would apply on mobile money transactions. Based on that, consideration, even though the proposed bill reduces the tax to 0.5% and limits it to withdrawals, it is still not neutral, fair, equitable, and has additional dangers of retarding growth of financial inclusion. Stakeholder number 2, Ministry of Finance, Planning and Economic Development. They also suggested that while the value of transactions on the mobile money platform has significantly increased over years from 18.6 trillion in 2013 to 63 trillion in 2017, the revenue generated from imposing tax on transactional fees has been minimal. The revenue from the tax on transaction fees charged by telecom companies have risen from 37.7 billion financial year 2015-2016 to a paltry figure of 57.2 billion in financial year 2017-2018. As a portion of GDP, the velocity of mobile money transaction now stands at 63% of the GDP. They further urge that the tax does not apply on alternative payment platforms such as Easy Money, Payway, and agency banking, which poses a challenge of equity. This may lead to people opting for such services instead of mobile money, which may negatively impact on the growth of mobile money platform and eventually tax yield from the measure. We go to stakeholder number 3, telecommunication operators. They say that the proposed 0.5% on tax on mobile money service is discriminative, considering that the same tax has not been imposed on financial services and other payment channels, which serve the same purpose as the mobile money service or any service that allows flow of money from one person or business to another, including business to person or person to businesses. They submitted that the tax should be dropped because of negative effects it has had on the sector. Then we go to stakeholder number 4, Kampala Mobile Money Dealers Association. They proposed that since the tax has a negative effect on small and medium enterprises who are key users of mobile money, it should be dropped. Right, Honorable Speaker, I'm summarizing because of time. Then we also made stakeholder number 3, number 5, Initiative for Social and Economic Rights. They urged that mobile money services have enabled easy payment for goods and services with convenience with the number of utility companies, insurance companies, schools and health centers receiving payments through mobile money. They also proposed that it should be dropped. Then Tax Justice Alliance Uganda they proposed that the proposed tax will cause multiple taxation. This is in addition to an increase from 10% to 15% excise duty tax on charges imposed for use of mobile money services and a new 10% excise duty on commission for mobile money and airtime agents. It further proposed that the customer pay another 0.5% tax on every withdrawal transaction that he or she makes. It is important to note that the income from which transaction charges are imposed, which charges are being taxed at 15% per charge, is the same income that the proposed 0.5% tax is intended to tax. This is double taxation. That is now discouraging people from using mobile services since the tax was imposed on withdrawal. They propose that should be dropped. Civil Society Budget Advocacy Group, they also propose that reducing the tax rate on transaction value to 0.5% only serves to reduce the impact on profits and transaction volumes by 50% to about 37.3%. 35% of the interviewed proprietors had laid off some workers. 33% reported to have closed businesses due to failure to meet some overhead costs like rent and facilitation of the people they employ in mobile money kiosks, while 11% has resorted to other businesses like a payway, easy road only. This indicates that a tax on mobile money transaction is regressive. Right Honorable Speaker, we also made the MTN Dealers Forum. The MTN Dealers Forum submitted they said that MTN Dealers Forum submitted that from 1st July 2018, at least 100,000 customers served daily have reduced by 40% to date, and it continues to go down by day. There are no customers anymore transacting over 1 million shillings, Right Honorable Speaker. Urban to rural cash transfers have dropped by 40%, affecting customers cash out negatively. They propose that the tax should be dropped. Honorable Akamba, MP Wesiki County, submitted that there is no legal framework. There is no legal framework to regulate mobile money business in Uganda. The Bank of Uganda Act did not provide the regulator with general authority to regulate the payment sector. Uganda did not and still does not have a payment law that can be used by central bank to issue licenses to electronic money users. At the same time, only banks and their institutions regulated by Financial Institutions Act 2004 are permitted to provide retail services. He also proposed that the tax should be dropped. Right Honorable Speaker also met Uganda Bankers Association. Uganda Bankers Association submitted that they hold the opinion that the specific taxes on mobile money transactions as had originally been proposed work against the objectives of financial inclusion and would reverse the gains that had so far been realized on this front. They also proposed that the tax should be dropped. I'm about to summarize, to finish, Right Honorable Speaker. Private Sector Foundation. Private Sector Foundation submitted that all direct taxes scare away users to mobile money. There is already a reduction by 60% experienced. This has directly affected all businesses which use mobile money as a mode of payment. They also proposed that the tax should be dropped. Mwema and the company advocates, Right Honorable Speaker, I'm about to conclude. They made that without a proper cross-licensing regulatory framework of mobile money services, the telecoms and other mobile money service providers are strictly speaking caught by an illegality of conducting banking business contrary to the Financial Institutions Act 2004. They also proposed that the tax should be dropped.
Information. Yeah. Information.
Members' observation, Right Honorable Speaker, I'm summarizing. Taxation should produce the right amount of tax at the right time, while avoiding both double taxation and unintentional non-taxation. The potential for evasion and avoidance should be minimized to the extent that imposing this tax to mobile money withdrawals may be the most preferred option to adopt at the moment. It could create various forms of avoidance and evasion. The members also proposed that it should be dropped. Right Honorable Speaker, I call upon Honorable Ishaji for the recommendations.
Thank you, Right Honorable Speaker and my colleagues. Right Honorable Speaker, I would start by thanking the Minister for bringing this amendment. I think it's a chance for us to really handle the issue and drop everything. Right Honorable Speaker, you see, the first one could have been testing the depth of the river with one leg. The mistake we must not make is to try to check it, the depth with both legs. Right Honorable Speaker, this tax, we benchmarked beyond our borders. We benchmarked with Mauritius, with Zimbabwe, Kenya, Tanzania, and Pakistan. Thank you. The finding is it's only Uganda and the poorly managed Zimbabwe who have imposed this tax. Zimbabwe imposed a transaction tax of $0.05 per transaction. Now, the amendment the minister is proposing, from 1% to 0.5%, it's not a quantum problem. The problem is a logical one and the principle of the tax, as you've heard. You see, mobile money operations, colleagues,
is a revolution. It's a revolution. It's a growth factor. It's a revolution we should not miss. And it's a product which is still at its infant stage. So when a product is at infant stage, which is going to bring a lot of benefits, it will be totally wrong for us to inject shocks to this product. This is a product which is going to, you see, logically, the side of government, manifesto of the government, is employment, poverty reduction, and this is a vehicle which is going to support us on that. Yes. When we talk about equity, we talk about equal opportunities. Banks are not reaching the rural areas. But the mobile money goes deep up to the rural area. And as such, we don't have to play about with the mobile money. You see, when the minister is talking of being kind, the minister is telling us of being kind, of reducing from 1 to 0.5%. Let's look at elasticity. Elasticity principle. What is the responsiveness? If you have a product, what's the responsiveness? What's the responsiveness to price? If there is any increase or reduction in price, what's the degree of responsiveness? And what's the degree of responsiveness of the consumer to taxation? Morally, this tax is terrible. It even flashes on your face. It even flashes and it's a big shock. Chair, I beg your pardon, Right Honorable Speaker. Legally, we are supposed to legislate correctly. Excise duty is a tax to a supplier of service or goods. But you are not going to again put excise duty on a consumer. Legally, this tax does not fall within the Excise Duty Excise Act. If you check the Excise Act which was passed by Parliament, it doesn't fall there. You can't tax the consumer. You should. Now, what is happening is we are avoiding to tax the right person. The mobile money, I mean the telecommunication companies, are charging a lot of money. That is the money. We are talking of financing their budget. That's the money we should go for. Yes. We don't need to go for double taxation. We just go and increase, bring an amendment to increase the percentage.
Point of order.
Right Honorable Speaker, this member was invited to present recommendations and is here debating. Is he in order to debate while he was invited here to give recommendations?
Honorable members. Honorable members, I don't know whether you have the same copy of the report that I have. The Honorable Opolot Isiagio Patrick, member for Kachumbala, NRM, is a signatory to the minority report. And that is exactly what he's doing.
I thank you, Right Honorable Speaker, for that wise counsel. Right Honorable Speaker, it's not good. Even when you check our main report, it clearly indicates that the operations have fallen by 30%. Yes. The jobs have fallen by 40%. How can we afford lose all those jobs? What's the gearing? You see, in management, it's like driving a manual car. You engage the right gear at the right time. If you are going to climb a hill, engage gear 2. But you may also decide to use gear 5 and come at a speed, and you climb the hill. However, the engine of the car will be damaged. Colleagues, when you check with Kenya, Kenya has gone ahead to provide what we call to give affirmative action for the poor, whereby the mobile money to the poor, these ladies who sell Skumawiki and so on, even the telecom companies don't charge them. They give a threshold. Below this amount, they don't charge those ones. When you check with Pakistan, the Easy Pice, which is a mobile money operator, also allows the use of money to send to the rural poor women without charges. Now, we beg, Right Honorable Speaker, colleagues, we need to save our people. We are representatives of the people. We cannot legislate and pass, like Right Honorable Speaker here said, are you going to vote yes for what is wrong? We cannot continue, even after. We cannot continue, even after understanding that what we have done is wrong. Apology to the public. And how do we apologize? By totally. Our prayer, Right Honorable Speaker and colleagues.
Honorable member.
Our prayer is...
Honorable member.
Yes.
When did I say that?
I beg your pardon, Right Honorable Speaker. I heard it just a few minutes ago when we were seeking leave for, after the Attorney General explained the circumstances. Thank you. Right Honorable Speaker, our prayer therefore is for the House to amend the excise duty Bill 2018 by totally scrapping, deleting, because even if you said 0%, that is equally wrong. Even 0 is bad enough. Yes. It must be totally deleted from the act, and this tax should be dispersed. Yes, aye. I beg to move. Yes. Aye. Aye.
Motion.
Right Honorable Speaker, having heard the minority report and hearing and seeing the mood in the House, which is seemingly so popular, I move a motion that the minority report be adopted. That the question be put for us to adopt the minority report and to drop the majority report. I beg to move.
Motion for, is it seconded? Raya, Busia Municipality, Kira Municipality. Okay, honorable members. The motion that has been proposed is that the question be put. And the question I am being requested to put is on the motion for second reading of the bill. But I must first put the question, the motion that the question be put. Okay? So I'm now going to put the question to the question that the motion, that the question be put. I put the question to the motion that the question be put. Now, will those in favor say aye to the contrary? No. Aye. The ayes have it. Honorable members, I now come to the motion that I've been called upon to put the question to. And let me guide. Let me guide. I'm putting the question to the motion, but this is the implication of the question I'm going to put. If we put the question, if we adopt the motion for second reading of the bill, that means then we go to committee stage to deal with the amendments. If we reject the motion for second reading, that means we have rejected the bill, then the law remains as it was passed. Okay?
You want to go to committee stage. You're right.
Let me explain again. Let me explain. Please. Honorable members, please listen. You need to listen. Two proposals have been made. The bill is proposing 0.5%. The minority report is proposing something else. But we have already passed 1%. So the operating law is 1%. So this bill seeks to amend that 1%, to change the percentage or remove it altogether. Okay? So if we vote yes for second reading of this motion, it means we go to committee stage to deal with the amendment. If we vote no, that means we are upholding the 1% in the previous bill. So I put the question to the motion that the excise duty amendment number 2 bill be read the second time. Will those in favor say aye? To the contrary, no? Aye. The ayes have it. Microphone.
The Excise Duty Amendment Bill number 2, 2018. Bills Committee stage. Clause 1.
Honorable members, I put the question that clause 1 stands part of the bill. Will those in favor say aye? To the contrary, no? Aye. The ayes have it.
Clause 2.
Clause 2.
Procedure, Mr. Speaker.
Clause 2.
Procedure, Mr. Speaker.
Procedure,
Mr. Speaker.
Procedure.
Mr. Chairman, we are dealing with a very sensitive law.
Honorable members, we are now coming to the actual amendment in clause 2. We have only dealt with the commencement.
That's the procedure, Mr. Chairman, I wanted to raise. Because the procedure I wanted to raise relates to the way we vote on clause 2. This is a very sensitive law. Actually, the mood of the population, the people we serve, has been captured well by the minority report. And therefore, the question of procedure I wanted to raise is that we do not adopt the voice voting method, but we vote by show of hands on clause 2. I so move.
Honorable members, there is no reason for anybody to be excited. I don't see where the excitement is coming from. We will adopt voting by show of hands. Can we proceed with this matter, please? Can we proceed? Please. Microphone.
Close to.
Close to.
Mr. Chairman. Mr. Chairman.
Close to. Can I put the question close to?
No.
Microphone.
Exactly. Let me wait.
Thank you very much, Mr. Chairman. The proposal contained in the minority report is a proposal to delete the provision that introduced this tax. If we vote on clause 2, to say, for example, we reject the proposal by government of 0.5, it actually means that we are reinstating 1%, so we want to maintain the status quo. So therefore, Mr. Chairman, before we go on clause 2, we have an amendment to make, and the Honorable Nuwagawa is making the amendment, if you can allow us.
Proposing the amendment.
Mr. Chairman, we do propose that clause 2 of the bill be amended with the following wording. The Excise Duty Act 2014, this act referred to as the Principal Act, is amended in Schedule 2, Part 1 by substituting for paragraph F of item 13 the following. F, mobile money transaction of withdrawal of cash of 0.5% of the value of the transaction is hereby amended by deleting the entire provision in the Act as passed in 2018.
Honorable members, in order for you to appreciate the amendment being proposed, I think it could have been drafted better. If you want to delete paragraph F, you would have just dealt with the first part without going to the one in the box, in which case it would have been something like the Excise Duty Act 2014. Is it 2014? No, the Excise Duty Act 2014, in this act referred to as the Principal Act, is amended in Schedule 2, Part 1, instead of by substituting, say, by deleting paragraph F of item 13. Is that what you're trying to say? Yes. Because to go to the box, it complicates the drafting. Yes, so, okay, that is the amendment that has been proposed. Yes. Can I put the question to this amendment? Yes, Mr. Chairman. Can I put the question to this amendment? Yes. The question I'm going to put is that the Excise Duty Act 2014 in this act referred to as the Principal Act is amended in Schedule 2, Part 1 by deleting paragraph F of item 13. That is the proposal. I'll put the question to that amendment. Will those in favor put up their hands? Excuse me. Please wait. Who is counting? Who is counting? Where?
Honorable Speaker.
Procedure. Point of procedure.
Thank you.
Honorable members, there is no need to create excitement.
Thank
the
you,
Honorable Jacob Olanya is in charge. There is no point for any member to get excited about this thing.
Thank you, Mr. Speaker. Mr. Speaker, when a matter was before the Supreme Court in Mbale, those who took the matter in court raised an issue of quorum in the House, and therefore, not to be caught, the members have articulated that the matter is so important, and as it is so important, I want to request that the matter of quorum has been moved outside this House, and that we ascertain the quorum of the House as we go to vote.
Honorable members, clerk, please ascertain quorum.
We are so legalistic. Schedule F of paragraph Y, as in if you had read it in verbatim, so that they understand that the schedule says X, Y, and Z. Amazing. No, you and I understand. This is the schedule. I understand. So what is complicated? Those that are following, say, well, this is your penalty, sir.
Quorum is there.
Honorable members, we are going to vote. You cannot go out.
Yes, this one you cannot go out. This one you cannot go out. Quorum is there. Quorum is there. How can you do that? How can you do that?
Honorable members, please just resume your seat and wait.
We have 97 quorum, 154.
Honorable members, this is the numbers that have been ascertained. The quorum of this parliament is 154 members. The members who are present in the chambers right now are 97. Honorable members, order. The rules require that at the time when voting is called and the numbers are not sufficient, I am required to suspend the House for 15 minutes to allow suspend the House for 15 minutes and then come back so that we can take this decision. Honorable members, let me remind you, whether you defer this vote by a year or 2 years, the results are likely to be the same. So I would request that we order. I would request that to uphold the dignity of this House, I suspend this House for 15 minutes, we constitute quorum and take this decision. Whether we take it today, whether we take it next week, the results are going to be the same. Can you send me back so that I can suspend the House?
Motion for the House to resume.
Honorable member? Yes.
Mr. Chairman, I beg to move that the House do resume and the Committee of the Whole House reports thereto.
Honorable members, the motion is for resumption of the House to enable the Committee of the Whole House report. I put the question to that motion. Will those in favor say aye? To the contrary, no. The ayes have it.
Report from the Committee of the Whole House.
Honorable Minister.
Mr. Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled the Excise Duty Number 2 Amendment Bill 2018 and passed Clause 1.
Motion for adoption of the report of the Committee of the Whole House.
Honorable Minister.
Mr. Speaker, I beg to move that the report from the Committee of the Whole House be adopted.
Honorable members, the motion is for adoption of the report of the Committee of the Whole House. I put the question to that motion. Those in favor say aye. To the contrary, no. The ayes have it. Honorable members, the challenge we have is that the House is not properly constituted to take a decision. The rules require me to suspend for 15 minutes. House suspended for 15 minutes. We resume here to take the appropriate decision on this motion.
Suspended.
Where is your voter? Where is your voter? Where are your voters?